Hello everyone, a very good afternoon. Please join in quickly so that we can start with the session. Alright. So just let me know if you can hear my voice. Am I audible to you? So good afternoon once again, and today's topic, we are starting with Indian Evidence Act, and today's topic is basically burden of proof. Very good afternoon. Alright, so today's topic is burden of proof. Fine. Alright, can you see the board? दिख रहा है आपको? I think it is visible. Alright, see, अब quickly start करते हैं. Let's start with the first topic of Monday. See, try and understand. जब भी कोई जुडिशियल प्रोसीडिंग होता है, whenever there is a judicial proceeding, so उस judicial proceeding में, as you know, when you read Indian Evidence Act, so there are, जब भी कोई judicial proceeding start होता है, alright, whenever a judicial proceeding starts, so what happens? You have to ascertain some rights, alright, और liability. यानी उस जुडिशियल प्रोसीडिंग में हम क्या करते हैं? जब भी कोई केस, मैं सिंपल भाषा में बात करती हूँ, जब भी कोई केस चल रहा होता है कोर्ट में, सो कोर्ट में आप क्या करते हो? कोई एक फैक्ट होता है, उस फैक्ट से जो है कुछ राइट्स क्रिएट हो रहे होते हैं या कुछ लाइबिलिटी क्रिएट हो रही होती है. येस और नो, ये बात समझ में आ रही है? कोई भी एक फैक्ट होता है, ठीक है, क्विकली इन वन लाइन आई एम जस्ट ट्राइंग टू एक्सप्लेन यू. उस फैक्ट से, अब वो फैक्ट, वो हम लोग इस पे डिस्कशन करेंगे, वो फैक्ट एंड इशू हो सकता है, ठीक है. फैक्ट एंड इशू को प्रूव करने के लिए हम रेलेवेंट फैक्ट यूज करते हैं, ठीक है. इसके बारे में हम बात करेंगे, बट मैं एकदम सिंपल टर्म्स में आपसे बात कर रही हूँ कि जब भी कोई जुडिशियल प्रोसीडिंग होता है, व्हेनेवर देयर इज अ जुडिशियल प्रोसीडिंग, तो हम क्या करते हैं? हम कुछ राइट्स एसर्टन करते हैं या प्रूव करते हैं, या फिर हम लाइबिलिटी एसर्टन करते हैं या प्रूव करते हैं या डिसप्रूव करते हैं. येस और नो? भाई बताओ येस नो, तब तो मैं आगे चलूँ, ठीक. Also, let me know if you can hear my voice because I am speaking slowly today. So, let me know that. यहाँ तक क्लियर है? अब ये, ठीक है, ये राइट्स एंड लाइबिलिटीज जो हैं, जो कि किसी फैक्ट से आती हैं, which comes out of a fact, this you have to prove to the satisfaction of the court. ये आपको कोर्ट के सामने प्रूव करना होता है. बर्डन ऑफ प्रूफ जो है वो ये बताता है, बर्डन ऑफ प्रूफ में बेसिकली ये बात की गई है कि भाई ये जो फैक्ट्स से, जो फैक्ट्स रखे जाते हैं प्लीडिंग्स में या केस में, इस फैक्ट से जो राइट्स और लाइबिलिटीज अराइज हो रही हैं, आई एम टेलिंग यू इन द सिंपलेस्ट टर्म्स, बहुत ध्यान से सुनिएगा, इस फैक्ट से जो राइट्स एंड लाइबिलिटीज अराइज हो रही हैं, इस राइट और लाइबिलिटी को प्रूव करने का बर्डन किसके पास है? दोनों पार्टीज में से, देयर आर टू पार्टीज इन द कोर्ट, दोनों पार्टीज में से इस राइट या लाइबिलिटी को प्रूव करने का बर्डन किसके पास है? आउट ऑफ द टू पार्टीज, विच पार्टी हैज द ऑब्लिगेशन टू प्रूव अ fact which give rise to some rights or some liability. Is it clear? ठीक है, बात समझ में आ रही है मैं क्या कह रही हूँ everyone? So if you have understood this, then you will understand कि हम आगे, so basically burden of proof जो है आपका वो कहाँ फॉल करता है? वो चैप्टर 7 में फॉल करता है. पीटी पॉइंट ऑफ व्यू से कुछ फैक्ट्स हैं. Where does it fall? It falls under chapter 7. And burden of proof particularly is from कहाँ से कहाँ तक? Let me write sections 101 to 111. Sections 101 to 111 basically talks about burden of proof. Sections 101 to 111 basically talks about burden of proof. Clear? राइट अब इसमें जो है दो चीज़ आपको याद रखनी है. सो बेसिकली यू नो द स्ट्रिक्ट मीनिंग, बेसिकली अगर देखा जाए, सो एक टर्म यूज़ होता है, लैटिन टर्म. द स्ट्रिक्ट मीनिंग इज बेसिकली बर्डन ऑफ प्रूफ को हम क्या कहते हैं? बीओपी को हम क्या कहते हैं? हम कहते हैं, व्हाट डू वी कॉल इट? वी कॉल इट ओनस प्रोबेंडी. ठीक है, ओनस प्रोबेंडी. Alright, for your preliminary purpose, they might ask you, you can use this line in your mains also. Now, when you see burden of proof, so there is a fixed burden of proof, which is just अभी जितना मैं बता रही हूँ उतना याद रखिए, 101. ठीक है? And there is shifting burden of proof. Shifting burden of proof. That is 102. Alright, so fixed burden of proof, shifting burden of proof. So shifting burden of proof, here you have to provide evidences. Now I'll talk about it. Let's talk about it one by one, that what are these different burden of proof. Okay. Alright. Fine. Okay. ठीक, so सबसे पहला क्या है? Section 101. Please open your Bear Act, all of you, so that we can quickly finish it. Please open your Bear Act. Section 101. Now what does it says? What does Section 101 says? Right. So whoever desires any court, please read your Bear Act. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts, ये मैं आपको पहले explain कर चुकी हूँ. So section 101 is basically telling you that you know what is a burden of proof. So whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. कोई भी अगर कोर्ट के सामने जाके, ठीक है, एनी पार्टी, कोई भी अगर, चाहे वो प्रोसिक्यूशन हो, चाहे वो डिफेंस हो, चाहे वो प्लेंटिफ हो, चाहे वो डिफेंडेंट हो, बिकॉज वी नो दैट इंडियन एविडेंस एक्ट अप्लाइज इन बोथ क्रिमिनल एंड सिविल केसेस. ठीक, सो कोई भी अगर कोर्ट के सामने जाके, इफ दैट पर्टिकुलर पार्टी वांट्स द कोर्ट टू गिव अ जजमेंट एज टू व्हाट, एज टू एनी लीगल राइट और लाइबिलिटी, और वो लीगल राइट और लाइबिलिटी किस पे डिपेंडेंट है? वो जो आप फैक्ट्स कोर्ट के सामने दिखला रहे हो उस पे डिपेंडेंट है. आप ये कह रहे हो कि ये जो फैक्ट्स हैं इससे जो है वो लीगल राइट या लाइबिलिटी अराइज होती है. सो देन इन दैट पर्टिकुलर केस ये बर्डन ऑफ प्रूफ किसके ऊपर होगा, ये प्रूफ करने का बर्डन किसके ऊपर होगा कि हाँ भाई इन फैक्ट्स से जो है ये लीगल राइट और लाइबिलिटी अराइज होती है। ये उस इंडिविजुअल पे होगा या ये उस पार्टी पे होगा जो कि ये कोर्ट को चाहता है प्रूफ, कोर्ट को चाहता है ये एक्सेप्ट करना कि येस दीज फैक्ट्स आर गिविंग राइट्स to these rights and liabilities, and that is why you want the court to pass a judgment in your favor depending upon those facts. Is it clear? ठीक है, is it clear? So when a person is bound to prove the existence of any fact because he is asserting that fact in front of the court with respect to a particular right or liability, तो देन उस केस में वो जो बर्डन ऑफ प्रूफ है वो किसके ऊपर फॉल करता है, वो बर्डन ऑफ प्रूफ फॉल करता है किसके ऊपर, उस इंडिविजुअल के ऊपर जो कि ये असर्ट कर रहा है। सो फॉर एग्जाम्पल आप अगर एक इलस्ट्रेशन इसका देखेंगे तो इसमें क्या लिखा हुआ है, ए डिजायर्स अ कोर्ट टू गिव जजमेंट दैट बी शैल बी पनिश्ड फॉर अ क्राइम which A says B has committed. A must prove that B has committed the crime. Now A has gone to the court. Let's suppose A is a prosecution. A has gone to the court and A say कि भाई B ने जो है वो चोरी की है. A goes to the court. ये burden of proof है. A goes to the court and says to the court कि भाई B ने जो है वो B has committed theft. कैसे आप बोल रहे हो, क्योंकि आपने कुछ फैक्ट्स जो है वो प्रस्तुत किए हैं कोर्ट के सामने, उसके बेसिस पे आप बी की लाइबिलिटी क्रिएट कर रहे हो। अब ये फैक्ट्स जो कि लाइबिलिटी क्रिएट कर रहे हैं, ठीक है, क्या चोरी हुई भी है कि नहीं हुई है, ये प्रूफ करना किसका काम है, ये बर्डन ऑफ प्रूफ किसका होगा, ये ए का होगा। क्लियर? आगे चले क्विकली। इज इट क्लियर एवरीवन? Now let's come to section 102. बाकी दूसरा इलस्ट्रेशन भी आप पढ़ लीजिएगा। हाँ ना बताते रहिए भाई, ताकि मुझे पता तो चले आपको समझ में आ रहा है। क्या बात है, आज आप लोग संडे के बाद सुस्त पड़ गए हैं, ढीले पड़ गए हैं थोड़ा। Yes please. All right. So that is why this is called as non-shifting और permanent burden of proof, क्योंकि यहाँ पे जो आप फैक्ट्स लेके जाते हो, कोई भी पार्टी जो फैक्ट्स लेके जाती है और वो चाहती है कि कोर्ट जो है वो उस फैक्ट्स के बेसिस पे जजमेंट पास करे, इफ द पार्टी वांट्स दैट द कोर्ट शुड पास द जजमेंट ऑन द बेसिस ऑफ दोज पर्टिकुलर फैक्ट्स, देन इट इज हुज बर्डन ऑफ प्रूफ, इट इज द बर्डन ऑफ प्रूफ ऑफ दैट पार्टी टू प्रूव दैट पर्टिकुलर फैक्ट। Alright, now let's come to 102 quickly. So on whom burden of proof lies basically? 101 was telling you, the permanent burden of proof. Basically, what is burden of proof? Section 102 tells you about like on whom it lies, because throughout the case, try and understand, throughout the proceeding is going on, it will not just lie on one person. It will go on shifting from one person to the other person, right? ऐसा तो नहीं है कि एक केस में एक फैक्ट्स को बस एक ही पार्टी को प्रूव करना है, दोनों पक्षों को प्रूव करना होगा अपने अपने फैक्ट्स। सो एक सिचुएशन में या पर्टिकुलर सिचुएशन में वो बर्डन ऑफ प्रूफ किसके ऊपर लाई करेगा, ये कौन बताता है, ये सेक्शन 102 बताता है, राइट? सेक्शन 10 tells you about that. It simply says, now let's suppose in this case we will continue this example. Let's suppose that in this particular case, theft wala case, B takes plea of alibi. What is plea of alibi? Anybody? Where is it provided? What is plea of alibi? It is a relevant fact. It is a relevant fact. What is plea of alibi? Provided under your section 11. ठीक है? Let's suppose in this particular case, which is also known as what was I saying? I just got deviated by this message. Anyway, so section 11, which also talks about a residuary section. Not IPC, it is an Indian Evidence Act Riddhi. Section 11 padhiyega, it is also termed as residuary section. Alright. So now what I am trying to say is, this plea of alibi is, let's suppose A says that bhai B ने theft commit किया है, ठीक है, but B says that I was not even there at that place. Exactly, that I was not even there at that place. अब अगर, now listen to me very carefully, अब अगर B ने फोटो प्रेजेंट कर दी कि भाई मैं तो शादी में था, I was in a marriage, alright, how are you saying that? तो यहाँ पे अगर A एविडेंस नहीं देगा, if A will not provide the evidence over here, when B has already presented a picture for his plea of alibi, so what will happen? What will happen? What will happen? Tell me. या मैं पहले से लेके चलूँ कि A is just saying that, so A has presented some certain evidences that, okay, fine, B has committed the theft because B was interested into it. There is some antique item, B has asked me, B had eyes on it. So A put up all these and A showed some chats also, some messages also, right? But B says that the allegation that has been put against me, so see, this is my plea of alibi. I was not even present at that place at that particular time when they are saying that I have committed the theft. So here on this particular fact, when the B presents plea of alibi, so on this particular fact, right, A can lose the case. So what will happen if A, so the burden of proof from B has shifted upon whom? It has shifted upon A. If A does not provide the evidence over here, so what will happen? A will lose the case. So what is shifting burden of proof? So shifting burden of proof is that at a particular moment, alright, if the person does not provide the evidence, so that particular person is going to lose the case. So when you read section 102, what does it say? It says the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. अब अगर यहाँ के बाद जो है, let's suppose B does not provide any evidence just by showing the picture and letter and everything and card. Let's see, I am there in this particular party, and A does not provide evidence over here and B has already proved his case. So who is going to lose the case? Nobody answered me. Who is going to lose the case? So has not the burden of proof shifted from B to A? नहीं समझ में आ रहा है? जल्दी बताओ. All of you, please. Has not the burden of proof? It has shifted from B to A, right? So A is going to lose the case if A does not provide any evidence. That is what shifting burden of proof is. That in a particular case, what happens? It's like a pendulum. ठीक है, ये यहाँ से यहाँ ऐसे ऐसे ये घूमता रहता है, right? It's like a pendulum. One party has to prove, then another party rebut, then if this party rebuts and this party does not provide the evidence, then what will happen? This party will lose the case. So it is like, it goes on moving from here to there. It's shifting. It's in a motion. All right. Till the time the case is finally decided. This burden of proof goes on shifting. All right. And there is nothing else to be proved. Clear? Right? So let's see the illustration and I think that will be more clear to you. Just a second, please. Alright, now let's come to section 103. We will take the same example only. Let's come to section 103. Sorry. Okay, let's come to section 103. What does it say? Okay, I have to read an example first. Let's read the illustration quickly. Let's read one example. A sues B for land of which B is in possession. A ने B को sue किया एक land के लिए. A ने B को sue किया किसके लिए? Land के लिए. There is this land, ठीक है, of which B is already in possession. बी के पास ऑलरेडी पोजेशन है उस लैंड का, ठीक, एंड विच एज ए asserts was left to A by the will of C, B's father. Now B's father, B के जो फादर हैं, sorry, B's father has died, and that is why B is in possession of this particular land. Now A asserts this, he asserts, ये जाके कोर्ट में ये कहते हैं भाई कि फादर ने, बी के फादर ने, बी एफ ने, ठीक है, बाय विल ये ज़मीन मेरे नाम पे कर रखी है. बाय विल दिस लैंड बिलोंग्स टू मी. ऑलराइट, दैट्स व्हाट ही सेज. फाइन. So that is why I am suing B, because B is in this possession. He should not be in the possession of this land, because by will, this land belongs to me. So if no evidence, now who has a strong case? Of course B, because B's father has, it is the land of B's father, and by virtue of it, B will be in the possession of that particular land. अब अगर यहाँ पे if no evidence were given on either side, तो क्या होगा? जस्ट बिकॉज आपके ये बोल देने से कि भाई विल के थ्रू जो है, भाई बी का एक फैक्ट है, आपका एक फैक्ट है, तो जस्ट बिकॉज ये बोल देने से कि बी के फादर ने मेरे फेवर में विल बनाई है, ये ज़मीन आपकी तो हो नहीं जाएगी. यू विल हैव टू प्रोड्यूस सम एविडेंसेस. सो इफ़ यू डू नॉट प्रोड्यूस एनी एविडेंस ओवर हियर, if you do not produce, if A does not produce any evidence over here, so what will happen? A is going to lose the case. A is going to lose the case, and B will, be in the possession of that particular land. Yes or no? So that is what your illustration says, that A sues B for land of which B is in possession, and which, as A asserts, was left to A by the will of C, B's father. So this person, C, B's father is C. Alright. If no evidence were given on either side, B would be entitled to retain his possession. Therefore, the burden of proof is on whom? The burden of proof is on A. Clear है या नहीं है? Is it clear or not? The burden of proof is on A. बताइए. Clear? अब हम 103 की बात कर रहे हैं. What is 103? So 103 is basically talking about the burden of proof to prove a particular fact. Burden of proof of a particular fact. Burden of proof of a particular fact. Alright. See, now if you want to prove a particular fact, right, and you want the court to believe in the existence of that particular fact, then on whom the burden of proof will lie? The burden of proof will lie on you, the person who is trying the court to believe on that particular fact. इसके लिए वही theft वाला example ही उन्हें दे रखा है. Now let's see how it is. Now let's suppose A ने, let's come back to the same example जहाँ से हमने start किया था. ये वाला एग्जाम्पल, थेफ्ट का चार्ज है, ठीक है. ए ने बी के अगेंस्ट थेफ्ट का चार्ज लगाया है. क्लियर? एंड देन ए सेज इन द कोर्ट दैट बी हैज गिवन दिस कन्फेशन टू सी. नाउ दिस इज अ पर्टिकुलर फैक्ट. आपको कैसे बताओ? राइट, दैट इज बीज फ्रेंड. But you are alleging and claiming or asserting this fact, which is a particular fact in the court, कि B is actually giving the confession to whom? To C, B's friend. So this particular fact has to be proved by A in front of court. ठीक है? That is what simply it is saying, that if you are claiming or asserting a particular fact, then that particular fact has to be proved in the court. Let's read quickly. The burden of proof as to any particular fact. For example, the plea of alibi, that is also a particular fact. Alright, so the burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is proved by any law that the proof of that fact shall lie on any particular person. ठीक है? Unless and until it is provided there somewhere in the law that it will lie on other person, but when you are pleading a particular fact, the burden of proof of proving that particular fact lies on you only. So A prosecutes B for theft and wishes the court to believe that B admitted theft to C. So what is going to happen? So A must prove the admission. So admission, confession, whatever, because that is a particular fact. And B wishes the court to believe. Now B also has a particular fact. B says मैं तो वहाँ था ही नहीं, as I told you about the plea of alibi. So that is also a particular fact. So that particular fact also needs to be proved by whom? It has to be proved by B. So B wishes the court to believe that at the time in question he was elsewhere. Alright, so he's taking a plea of alibi. So he must prove it. Clear? Right? Now आज हम सारा नहीं कर पाएंगे. We will be only doing till 105. ठीक है? So what is 104? Burden of proving fact to be proved to make evidence admissible. It's very simple. It is simply telling you that there is a evidence which you want to make admissible. आप चाहते हो कि एक particular evidence जो है वो admissible हो in the court of law. Right? You want that there is one particular evidence that should be admissible in the court of law. But in order to admit that evidence, for example, dying declaration, you want the court to believe into dying declaration. बट डाइंग डिक्लेरेशन को एज एन एविडेंस एडमिसिबल करने के लिए आपको सबसे पहले क्या प्रूव करना पड़ेगा? दैट जिसका डाइंग डिक्लेरेशन आप दे रहे हैं दैट पर्सन हैज डाइड, दैट इज व्हाई इट इज अ डाइंग डिक्लेरेशन. अदरवाइज इट विल बी अ कोरोबोरेटिव पीस ऑफ एविडेंस. येस और नो? दैट द पर्सन जिसका आप डिक्लेरेशन दे रहे हैं, डाइंग डिक्लेरेशन दे रहे हैं, दैट पर्सन हैज डाइड. सो दिस फैक्ट ऑफ डेथ has to be proved first in order to admit that dying declaration. ठीक है? क्लियर? बात समझ में आ रही है? यही कह रहा है सेक्शन 104 कि burden of proving fact. So I'll just break this down. It says burden of proving what? Fact. ठीक? And this fact, why it is required to be proved? To be proved to be proved to make evidence admissible. To make evidence admissible. To be proved to make evidence admissible. Clear? Alright, which evidence we are talking about here? We are talking about DD, dying declaration. We are talking about dying declaration. Are you able to see it? No, I guess. Let me shift this side. I think now you can see it. Okay, this is the scene. This is the scene. Right? That this fact of what? Fact of death. Fact of death need to be proved in order to make what admissible? This evidence of dying declaration admissible. This evidence of dying declaration admissible. ठीक है? Clear है? Alright? That is what it is saying. So illustration में भी आपके यही दिया हुआ है. Let me read that. The burden of proving any fact necessary to be proved in order to enable any person to give evidence of any other fact is on the person who wishes to give such evidence. It is on the person who wishes to give such evidence. Clear? Right? Then illustration says A wishes to prove a dying declaration by B. So A must prove B's death. That's what I told you. ठीक? Clear? Now, if you want to present a secondary evidence, like if you want to present a secondary evidence of a particular document, So when can you present a secondary evidence of a particular document? In cases, let's suppose, where the document is lost or destroyed. So what are you going to prove first? That the document is lost or the document is destroyed, then only you can present the secondary evidence. Clear hai? Is it clear with everyone? And the last section for today is 105, जो कि आप IPC में जनरल एक्सेप्शंस के साथ यूज करते हो. ठीक है? This is a section that you use in your Indian Penal Code with general exceptions. So section 105, what does it says? What does it says? So burden of proving that case of accused comes within exceptions. अब if the case of an accused, ठीक है, let's suppose, you know, it was a mistake of fact. Mistake of law is no excuse, right? Let's suppose it was a mistake of fact, or it was justified, you know, or it was an accident, or it was a case of intoxication, or it was a private defense, whatever, right? So if the case of the accused is falling under any of the exceptions, so the burden of proving that the case of the accused, so let's suppose, you know, he says that take the defense of insanity, that B takes the defense of insanity in case of theft, right? So then in that particular case, or B takes the defense of intoxication, that I was so intoxicated that I couldn't realize that when did I pick up that antique item. मैंने आपको antique item का example दिया था, that the theft of an antique item. So I was so much intoxicated, and that was an involuntary intoxication, that I couldn't realize that when did I pick up that antique item and kept it in my pocket. Alright, so if for theft, even if you have removed it from a particular place, so you have committed the offense. Alright, so there can be allegation of theft. So ये जो burden of proof है कि your case falls within any of the exceptions, ये कहाँ पे, ये किसके ऊपर लाई करेगा? ये this will lie on the person who is asserting that, you know, he falls under or she falls under the general exceptions. अगर आप जनरल एक्सेप्शंस का यूज़ करना चाहते हो, सो ये बर्डन ऑफ प्रूफ आपके ऊपर, एक्यूज के ऊपर फॉल करेगा कि भाई ओके, इफ़ यू आर सेइंग दैट योर केस फॉल्स अंडर जनरल एक्सेप्शंस, देन द बर्डन ऑफ प्रूफ इज ऑन यू. ठीक है? So that is what it is saying. It's saying when a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within the general exception, right? Bringing the case within what? Within the GE I am writing, within general exceptions. Alright. In the Indian Penal Code, or under any special exception or proviso contained in any part. For example, in case of grievous hurt. Alright. So there is a provocation ka proviso or exception if someone has provoked you, right, for causing that grievous hurt. So there the punishment gets reduced. Alright. So any kind of proviso, any kind of special exception, any kind of general exception, if you assert, if the accused asserts that the case falls in these areas, then the burden of proof is on the where? Whom? Is on the accused who is trying to take the defense. As simple as that. इसमें बहुत ज़्यादा दिमाग नहीं लगाना है, इसको ऐसे ही समझना है. और इसको आप जितना बार पढ़ेंगे आपको क्लियर होता जाएगा. The more you will read, the more you will have a clarity on that. Alright? That's what I do. The more you read, the more, you know, and still there is a lot to learn. So जितनी बार आप पढ़ते जाएंगे उतनी बार clarity होती जाएगी. So I'll just read the entire section for you. When a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any of the general exceptions in the Indian Penal Code or within any special exception or proviso contained in any other part of the same code or in any law defining the offense is upon whom? Is upon him. Who is him? The accused. And the court shall presume the absence of such circumstances. So court will not presume पहले से ही कि अच्छा your case is falling under general exception. The court will presume the absence of circumstances. So that is why the burden of proof is on you, like on the accused, to prove कि भाई मेरा केस तो इसमें फॉल करता है, लेकिन कोर्ट पहले से ये प्रिज्यूम करके चलेगी कि ऐसा कुछ भी नहीं है. So for example, A accused of murder alleges that by reason of unsoundness of mind he did not know the nature of the act. The burden of proof किसके ऊपर है? The burden of proof is on A. Clearly, right? So there is also illustration given of section 325. I would request you that please, you just go through it. These are very easy provisions. Once you go through it, once you try to understand, you will be able to learn. But never leave illustrations in your Indian Evidence Act. Whether you talk of Indian Evidence Act, whether you talk of contract or any act for that, IPC, these illustrations make the entire act complete. So you cannot leave the illustrations and go in exam. Always study your illustrations well. आप अगर illustration समझ गए हैं, section समझ गए हैं, so you don't need any other content for the purpose of the exam. All right, we will continue from here, tomorrow. So thank you so much, all of you. For today, I'll just stop over here and we can meet in the next class. Thank you. Take care. God bless. And yes, if you're new to the channel, do not forget to like and subscribe and share. Please share and like it and subscribe to it. All right. Thank you. God bless.